I'm Nicole Hemrick, and I'm the founder and managing partner at Hemrick O'Malley, PLLC. I'm sure many of you have heard in the news reports of students on visas being detained, SEVIS being canceled, and these are strange times. And I just wanted to break some of this information down for you, what it means, what you can expect at this point. And maybe this will help to clarify the issues and also ease some of your anxiety. So basically, what's been going on is that as of March, immigration enforcement has been going after international students, that's people on F-1 visas, and other campus members. Many colleges and universities have reported discovering instances of student records being terminated in the SEVIS, which is Student Exchange and Visitor Information System by the Department of Homeland Security's ICE, the Immigration and Customs Enforcement, and the Exchange Visitor Program. These actions, of course, have generated many questions and concerns. First of all, let's talk about what is a visa. The visa is the document or stamp in your passport that says the way in which you are permitted to come into the United States. So if you are a student, it would say that you have an F-1 visa. Other types of students are J-1 exchange visitors or M-1 student visas, and this is for non-academic or vocational study or training. All the student visa itself does is give you permission to enter the United States for a period of time. Once you are here in the United States, you must maintain status. The time permitted on your status is listed on your Form I-94, which is accessible at www.cbp.gov. And students are granted admission for duration of status. It'll say D/S. What that means is as long as you are doing the things you are supposed to as a student, attending your classes, paying the school, that you are maintaining your status. We talked about the fact that there have been visa revocations. A visa can be revoked if a consular official of the Department of State determines that the individual is no longer eligible for this type of visa classification. The visa has been physically removed from the passport in which it was issued. The person has an ident watch list record due to driving under the influence, driving while intoxicated, or a similar conviction within the past 5 years. Another thing that you should be aware of is what SEVIS is. This is the web-based system for maintaining information on non-immigrant students and exchange visitors in the United States. It is the core technology that DHS uses and has been using since after 9/11. SEVIS implements a section of the immigration law which requires DHS to collect current information from non-immigrant students and exchange visitors continuously during their stay in the United States. SEVIS also enables DHS to assure proper reporting and record keeping by schools and exchange visitor programs. It is a mechanism for students and exchange visitor status violations to be identified so that appropriate enforcement can be taken. That is, denial of admission, denial of benefits, or removal from the United States. Its purpose, according to the website, is to protect national security while supporting the legal entry of more than 1 million F, M, and J non-immigrants in the United States for education and cultural exchange. Now, what we were talking about at the beginning is that there have been SEVIS record terminations. So let's break down a little bit what this means. According to DHS, termination of a student's SEVIS record could indicate that the non-immigrant no longer maintains F or M status. Designated school officials, that is DSOs, may terminate F1 and M1 students and F2 or M2 dependents, that's their spouses or children, who do not maintain their status. Some of the reasons for a SEVIS termination are expulsion from the school, failure to enroll in a full course of study, failure to report while on OPT, not showing up, failure to report to the school, and other reasons. For example, working when you're not supposed to without proper authorization. The consequences after a SEVIS record termination are loss of all on or off-campus employment authorization, that's CPT or OPT, the student would not be able to re-enter the United States on the terminated SEVIS record. ICE agents may investigate to confirm the departure of the student, and any associated F-2 or M-2 dependent records would be terminated. While in the past, ICE was really not terminating SEVIS records, in rare instances, ICE reported information to the DSO that would lead the DSO to terminating the record, such as if the student was taken into custody by a law enforcement agent. The recent reports, however, is that ICE has been terminating SEVIS records based on protests and speech activity and prior arrests or convictions. These would be reported as the student's failure to maintain non-immigrant status, a violation of the conditions of such status, or activities that would have serious foreign policy consequences in the United States. Some have pointed to a lack of clarity about the legal basis of these terminations. So what happens after a revocation? First of all, anybody whose visa has been revoked can be charged with removability from the United States and placed in proceedings before an immigration judge. During the hearing, DHS has to provide the basis for your removability. So this would be on the notice to appear, otherwise called the NTA, which is the acronym. And you would have the opportunity to defend yourself from removal by submitting a defensive application. If you are placed in removal, it's very important that you contact a licensed attorney to assist you in your case. Now, if the visa itself is revoked, as long as you do maintain your legal status while here and you are meeting the requirements of your full-time enrollment and study program while maintaining a foreign residence, having sufficient funds, and other conditions for your student status, you can remain enrolled in your program because your immigration status for educational purposes remains valid. However, once you exit the United States, you will need to obtain a new visa to re-enter the country. What can you do if you encounter ICE? Of course, you maintain the right to remain silent. You have the right to speak with a lawyer. If you already have a lawyer, you can ask your attorney for a G-28, which is the notice of appearance for an attorney, and provide this to DHS so they know you have an attorney that you want to speak with before answering any questions. Also, in preparation, you can make sure that somebody else, a trusted family member or friend, has copies of all of your immigration documents. I hope you have found this information helpful. We are here if you have any questions. Feel free to reach out to us at 833-848-7838 or check us out online at www.hemrick.law.